यार मदर से हाँ तुम्ही कंडक्ट करणार
मीटिंग से है ना। आपल्या क्वेश्चन पेपर मध्ये फक्त हेडचे निघाला.
नाही त्याचं जर्नल कम्प्लीट आहे बघा चेक मी तुम्हाला सांगतो लॉस असेल
नाही फक्त शांतच बापरे
पापा शाम तक बंद है। नहीं नहीं Sir, shall we start?
Yes, madam, proceed.
Okay, sir. Good morning, one and all. I am Selina Meshra. On behalf of Mahatma Phule Arts
Shall we start?
Commerce College, Panvel, welcome you all for this.
Yes, madam, proceed.
I welcome you all to
For
this online Monday workshop
the
on intellectual property,
property rights.
jointly organized by RAGE,
Rayat Shikshan Samsthas, Mahatma Phule Arts
and Student Education Society.
Societies, College of Management and Technology, Wuran District, Raigad. It is my pleasure to welcome Honorable Principal Dr. Meenakshi Gupta, Wuran Education Society's College of Management and Technology, Wuran. It is also an honor to welcome Honorable Principal Dr. Ganesh Thakur sir, Mahatma Phule Arts, Science and Commerce College, Panvel, who is also the president of today's workshop. It is my privilege to welcome today's resource person, Dr. Pramod Thakur, Assistant Professor, Department of Chemistry from Mahatma Phule AC College, Panvel. I also welcome Vice Principal, Dr. R.A. Patil sir, Professor Dr. Naresh Madhvi sir, IQAC Coordinator, Mr. Sopan Gove sir, Mrs. Varsha Veer Madam, our technical help, Mr. Gun sir. I also welcome eminent guest, academicians, research scholars who are connected to us through Zoom and also live streaming through YouTube. We are delighted to have the participants from the diverse background and different locations which are joining us for this workshop. The goal of today's workshop is to enhance our understanding on intellectual property rights, their legal implications, and significance in digital age. Understanding IPR enables us to protect the creation of human mind, such as innovations, artistic works, designs, symbols, images, and also encourages creativity. As understanding IPR are crucial in today's knowledge-driven society, we once again welcome all the participants and eminent guests for this workshop. Mr. Sopan Gove, IQAC Coordinator, Mahatma Phule College, has been integral part of organizing this workshop and contributing tirelessly to make this workshop a success. I request Mr. Sopan Gove, sir, to brief us about today's workshop on intellectual property rights. Mr. Sopan,
Thank you, madam. Good morning to one and all. Dignitaries present on the online platform for this one-day workshop on intellectual property rights. Honorable Principal Dr. Ganesh Thakur Sahib, Principal Mahatma Phule Arts, Science and Commerce College, Panvel. Honorable Principal Dr. Meenakshi Gupta, Madam, Principal of Uran Education Societies, College of Management and Technology, Uran. Resource person of the workshop, Dr. Pramod Thakur Sir, Assistant Professor in Chemistry, Mahatma Phule College, Panvel, and their participants present online from different states and institutes. On behalf of the IQCs of both the institutes, I welcome you all for this workshop on intellectual property rights and take this opportunity to share the purpose behind the organization of the present collaborative activity. Mahatma Phule Arts, Science and Commerce College, Panvel has recently achieved A+ grade in NAC accreditation cycle 4 with CGPA score of 3.29, and Uran Education Society's College of Management and Technology, Uran, is about to go for NAC accreditation cycle 2nd. Organization of collaborative activities and exchange of the expertise with other academic institutes have substantial importance in the context of NAC assessment and accreditation process. Keeping this purpose in mind, the IQCs of both the colleges have signed a MOU to strengthen collaborations and linkages with other institutes. The present workshop is an offspring of the MOU signed by our institutes. I feel privileged to note that principals of both the institutes, Dr. Ganesh Thakur Sahib and Dr. Meenakshi Gupta Madam, have provided required support and guidance for organization of this workshop on IPR. The prime purpose of this workshop is to make the participants aware of the intellectual property rights and foster them in research ventures ethically. The resource person, Dr. Pramod Thakur Sir, is an expert in the field of IPR, and as he has personally published 6 Indian patents in recent past, I'm sure that his expertise in the field will enlighten us all and clear whatever the doubts we have. I conclude here with this short preface to the workshop. Thank you.
thank you, Gove, sir. Before we begin, I would like to make a quick note about the seminar workshop. Please keep your microphones mute during the presentation and also feel free to use the chat box and to ask your questions and share your thoughts. Your questions will be taken at the end of the session. Dear participants, it is my distinct honor to invite Honorable Principal Dr. Meenakshi Gupta Madam from Uran Education Society's College of Management and Technology to extend her warm welcome to all the participants and also to share her valuable thoughts to mark the beginning of this workshop. Madam, over to you for a welcome address.
Thank you so very much, Meena ma'am. Good morning to all present here. Ladies and gentlemen, it is with great pleasure and enthusiasm that I welcome you all to this distinguished workshop on intellectual property rights. We are honored to have such a diverse and accomplished group of participants gathered here today. In a world driven by innovation and creativity, understanding and safeguarding intellectual property rights is paramount. Our esteemed speaker and expert, Dr. Pramod Thakur, has graciously agreed to share his wealth of knowledge and experience with us. And I am confident that the insights gained here will be invaluable. I would like to extend my heartfelt gratitude to all our participants and organizers who have worked to make this event a reality. Your commitment to the promotion and protection of intellectual property rights is commendable. Let us engage in fruitful discussion and foster a collaborative learning environment. May this workshop be a platform for not only acquiring knowledge, but also for forging meaningful connections and collaboration. Once again, a warm welcome to each one of you, and I wish us all a productive and enlightening workshop. Thank you so very much.
Thank you, madam, for your kind words and such a warm welcome. We move to our technical session now. It gives me pleasure to introduce today's resource person for this invited talk on intellectual property rights. Dr. Pramod Thakur, a young, dynamic researcher whose passion for innovation and dedication to research have made a significant impact in the subject. Being the ex-student of our college, he has brought glories to the college while working in the Department of Chemistry as assistant professor. Dr. Pramod Thakur sir has completed his PhD in chemistry in 2015 from IICT Hyderabad. He has published 6 patents and also published 30 research papers in well-reputed international journals. He has presented 24 research papers in international and national conferences. He is also a recipient of 2 research fellowship awards with 11 years of experience in research, and he himself is also a recognized PhD guide in chemistry. He is also a coordinator of Raigad district for Avishkar Research Convention. With this brief introduction, I request sir to begin with the session. Sir, over to you.
Good morning, one and all. Am I audible?
Yes, sir.
Yes.
Okay. My screen is visible.
It is still showing that you have been sharing the screen.
Okay.
It is not visible yet. The message is you have started. Yeah. Try one more time. Yes.
It is visible now.
Yeah. Okay.
Okay, may I proceed?
Proceed.
Okay. First of all, I'm thankful to organizer for organizing such a workshop on very important topic, intellectual property right. The thing that we have to accept that most of the peoples who are intellectuals, but they are unaware about the intellectual property rights. So the topic for the webinar will be the introduction of intellectual property right, with special emphasis on Indian patent system, because as per the current data, it has observed that Indians are unaware about the Indian patent system. Uh, More than 60 to 65% patent which are filed in India are from the outside country companies, or we can say the companies which are out of the India. So Indian peoples are unaware about the Indian patent system, and only 10 to 15% patent which are filed in India are from the Indian people. The main reason behind this is the unawareness of the peoples about the intellectual property right and the benefits of the IPRs. So in this hot topic, we will discuss some basics about the IPRs. IPRs are containing different areas. Intellectual property are broadly classified as a industrial properties, which includes patents, design, trademarks. Second IPR area is copyright, and some other IPR areas are geographical indications, layout design of integrated circuits, and trade secrets. So these are the areas of IPR, and we are discussing each of this area in details. So these areas of IPR, in which the mostly talked area is patents. The patent is actually given for product or process invention. It is a exclusive monopoly right granted to inventor for his invention. So basically, this patent document is an monopoly right which is legally given to a inventors for invention of its product or the method for making of that particular product. Here are some example of the patents, like LED light bulb, universal coronavirus vaccine. It is very interesting to know that iPhone was patented in a title of electronic device. So in a detailed patent application, we can get lot of information, but the very famous device which is known as iPhone is actually patented in the name of electronic device, and the basic layouts of this device are shown here, which is actually present in the original patent application. Another title like preparation of polymeric resins and carbon material. So these are just an examples how the patent can be filed and what will be the title of the patent or what will be the title of the invention. The second area of IPR is a industrial design. The industrial design is for external features appealing to an eye. Any new shape, pattern, ornamentation, configuration, composition of colors or line or combination thereof as applied on an article. So anything new design, it can be protected under industrial design. These are some example which we can see that any article or any new design, if you have in your mind, you can draw it, you can make it, and you can protect it. So you can see the different examples shown here. The recent one is the Tata Motors car, next one, which is protected under industrial design. And anything is a new pattern as per your knowledge, you can protect it as an industrial design. If you see the journal published by Indian Patent Office in a design section, every new sari pattern is protected there. So if you see the journal, you can see the various cloths, designs, sari patterns are actually protected in a industrial design. It can be anything innovative design, it can be anything new design which you can think it is having commercial importance, then you can must protect it under industrial design. The next area of IPR is a trademark. We know that trademarks are very famous and they are important for the business because the business is known from their trademarks. The trademarks are given for visual symbols as word, name, logo, label, combination of color, etc. It is applied on an article of manufacturer or service to indicate the origin of manufacturer or service. So by looking at these logos, you can easily identify these belong to which company. So logos give the identity to the manufacturer or identity to the particular service provider. These unique logos can be protected under IPR in trademark section. The next area of IPR is copyright, and this is given for an artistic creation. It is an proprietary right and it come into existence as soon as the work is created. In copyright, one can protect the literary work, films, dramatic, musical, artistic, sound recording, all this kind of artistic creations can be protected under copyright. And it is very important to understand that copyright come in existence immediately as soon as the work is created when you approach for the particular office to protect your work. The another area of IPR is a geographical indications. Now, geographical indications are given for particular agriculture goods, manufactured goods. So it given to a particular agriculture, natural or manufactured goods which are originating from a definite territory in India. So some of the food items are very famous in particular area. They are the characteristic property of that particular area. They are the identity of that particular area. So that kind of things will be protected under geographical indication. It possessing a special quality or reputation. It is based upon unique characteristics of the geographical location. So some of the examples one can see which are protected under geographical indications like Nagpur orange, Ratnagiri hapus, and many other things. Darjeeling tea also come. Sometime a special thing like Tirupati laddus, they are also covered in geographical indication. So IPR is not only related to the patents. IPRs having different areas, and as we have discussed, the areas of IPR containing patents, industrial design, trademarks, copyright, and geographical indications. Apart from these different areas of IPR, my next focus of the topic is about patents, because patent is having much commercial importance, and as I discussed at the beginning, a very few peoples in India are aware about this intellectual property rights. As I discussed, the 60 to 65% patents which are filed in India are by the other country companies. Other country peoples are filing the Indian patents, and the ratio is more than 60 to 65%. And only about 20% peoples from the India are filing the Indian patent. And the main reason is the awareness of the patent system and awareness about how the simple can be a filing of patent. So the next session or the next part of the session will focus on the Indian patent system. Basically, in this session, we are going to cover how to file an Indian patent, what are the filing procedure for patent, what are the document required for filing the procedure, what is the fee structure for filing the patents, and very importantly, what is the timeline for getting patent. So all these aspects will be covered in the next session. Basically, what patent do for you, or what benefit you can get from the patent. If you file any patent for your invention, then it stops others from making, using and selling your invention. So if you have something inventive in your hand, you can file a patent for that, and after filing the patent it will give you rights. It will be your exclusive right, and it will stop others for making, using and selling your invention. So this is the most important benefit given by the patent. Basically, the patent system in India was introduced by British government by Act 6 of 1856, the Patent and Design Act 1911. At that time, the patent was allotted for term of 14 years. Now it is revised to up to 20 years. The Patent Act 1970 came into force on 20th April 1972. After this original Patent Act, there were many amendments, and it was amended in 1999, 2002 and 2005 under obligation of agreement on trade related aspect of intellectual property rights. During this patent system, the product patent were not allowed, only the process patent were allowed, but since 2005 the product patent were also allowed. These are the different IPR related acts which are followed in India. The first Indian Patent Act 1970, which was come in force in 1972, and it was amended in subsequent years like 1999, 2002 and 2005. As per the global development, the patent acts were modified and some new acts were added, like Convention of Biodiversity 1992. It is related to the biological process protections. Then the trade related aspect of intellectual property right agreement 1986. It is in force since 1995. Paris Convention 1883 and PCT 1978. This allow Indian people to file a patent in most of the country at a time, and India become member of this Paris Convention in December 1998. This Budapest Treaty of the international recognition of the deposit of microorganism for the purpose of patent procedure come in force in 1979, and India become member in December 2001. So these IPR related acts are governing the rules related to the protection under IPR. These are the silent feature of the Patent Act. The both product and process patent are provided in this Patent Act. The term of patent was granted for 20 years. Both pre-grant and post-grant opposition is possible in the Patent Act. A fast-track mechanism for disposal of appeals, provision for protection of biodiversity and traditional knowledge. This is very, very important amendment, we can say, which is come in a Patent Act. Provision for protection of biodiversity and traditional knowledge. I will just tell you one simple and very, very important story about this amendment for the protection of traditional knowledge. You might have heard about the story of the Haldi patent. Okay, the war which was with US and India about the patent of turmeric. In 1995, two persons from Mississippi University have filed a patent on turmeric, and after the 2 years, it was come to know that US have got a patent on turmeric. When these news come to India, Dr. Mashelkar, who was the director of CSIR, he was very shocked about this news, because from thousands of years we know the medicinal benefits of the turmeric, and one cannot take a patent on this known knowledge. So he designed a proper method to fight for this patent. He stayed in US for 6 months. He has produced several documents, nearly 32 references he has collected, which was more than 200, 500 years old, which containing Hindi, Sanskrit, and other regional language. He proved that the turmeric is known as a wound healing since thousands of years in India, and one cannot take patent on this traditional knowledge. US government has accepted the judgment and the patent was cancelled in 23 August 1997. So that was a important landmark in Patent Act to give protection for the traditional knowledge. One very important thing is that those two persons who have filed the patents is Harihar Kohli and Sumit Das were the Indians who were working in the university. And another interesting thing is that the patent officer who has observed their patent was also a Das from the India. So these three Indian people have tried to get a US patent on turmeric, which was already very well known in India. So after this war, which was won by the India with US Patent Office, the Patent Act was modified and the protection for traditional knowledge was given. And after this, the traditional knowledge digital library was formed. In India now there is a traditional knowledge digital library, and every patent which is given, first it will be searched whether it is present in Indian traditional knowledge library or not, and then only it will be granted. So this is very important feature of the Patent Act to give the protection for the traditional knowledge. Anything which is existing in a traditional knowledge that cannot be patented. Publication of the application after 18 months was another silent feature, facility for early publication and substantially reduced timelines. These are some important silent feature of the new Patent Act. These are some laws which are governed by Department of Industrial Policy and Promotion. These laws are related to the patent, trademark, design and geographical indication. So all these laws are followed for the giving protection under IPR laws. These are the some ministries which comes under IPR laws: Ministry of HRD for the Copyright Act, Ministry of Information Technology for the Semiconductor Integrated Circuit Layout Design Act, Department of Agriculture and Cooperation, the Protection of Plant Varieties and Farmers' Right Act 2001, Ministry of Company Affairs, the Public Act 2002. These are an overview of Indian IPR offices. There are different IPR offices for patent, design, trademark and GI registry. At Nagpur, an institute known as Rajiv Gandhi National Institute of Intellectual Property and Management, where all the patent officers are trained, and this can be treated as an apex institute of this IPR. The patent office which are located in 4 locations of the India are Kolkata, Delhi, Chennai and Mumbai. So one has to file the patent only in these 4 offices according to your area. Design office is present in Kolkata. If one has to file and design, he has to file the design in Kolkata office. Trademark registry are done at Mumbai, Delhi, Kolkata, Chennai, Ahmedabad. GI registry is done at Chennai. Again, the copyright registry will be done at Delhi office. So all these are the overview of Indian IPR offices. This is an overview of Indian Patent Office. So there are examiners who will evaluate your patents. Then there will be a joint controller, deputy controller and assistant controller, followed by the controller general. So the apex officer in patent office is the controller general, who is having sole authority to make a decision on your patent application. These are the jurisdiction related to the 4 patent office. So if somebody is residing in any of these states, they have to file the patent in particular patent office. For Mumbai Patent Office, a person belonging to the Maharashtra, Gujarat, Madhya Pradesh, Goa, Diu, Daman, Dadra and Nagar Haveli can file a patent. For Chennai Patent Office, the person related to the Andhra Pradesh, Kerala, Tamil Nadu, Karnataka, Pondicherry, Lakshadweep. For New Delhi, it is containing Delhi, Haryana, Himachal Pradesh, Jammu and Kashmir, Punjab, Rajasthan and Uttar Pradesh, Chandigarh. And for rest of the India, the Kolkata is a patent office. So any complications or any legal fights it will be done in this particular jurisdiction. Now, what is the criteria for patentability? If one has to file the patent, what you should have? What will be the basic criteria to get a patent, or what will be the thing which must be present in your invention to get it protected under patent? So particularly the patent can be or you can get a patent for all process and products which are new, means having novelty, involving inventive steps and capable of industrial application. Anything you are thinking which is can be protected in a patent should have these three characteristics. These are known as a requirement for patentability. It should be invention, it should have inventive step, and it should have capability for industrial applications. So anything you are thinking that it can be patented, it must have these three requirements. Now what is invention, what is inventive step, and what is capability of industrial application? It is itself defined in a Indian Patent Act. So as per the Indian Patent Act, what is an invention? In accordance with the provision of section 21J of the Indian Patent Act 1970, an invention means a new product or process involving an inventive step and capable of industrial application. So this definition must be understood, that if somebody is saying that I have done the invention, that invention should follow all these three criteria. It should be a new product or process which involving an inventive step, and it should have the capability of industrial application. So basically, what should not be considered as an invention? If anything which is published or used in India or elsewhere cannot be an invention. Anything which is in prior public knowledge or prior public use in India cannot be an invention. Here is the story of the turmeric. We can say that the turmeric was already known in public knowledge for the wound healing property, and those things which are already known to the public, which are used in the public, that cannot be an invention. And on this ground, the patent application of turmeric in US was rejected. The third thing, that anything which are claimed in any claim in specification files cannot be an invention. So if you have done any invention, that invention should not be published, it should not be in a prior public knowledge, or it should not be claimed anywhere in an application. So these are the important properties of your invention. If you fulfill this property, definitely you will get a patent for your invention. The second criteria was the inventive step. Again, inventive step is defined in a Patent Act. As per the section 21JA, inventive step means a feature of an invention that involves technical advancement as compared to the existing knowledge, or having economic significance or worth. Now see, inventive step means you have modified the procedure for making something. If you have find out the new method for making some new product or already known product, then your step must have technical advancement compared to the earlier method, and that technical advancement should be more as per the existing knowledge, or it can having economic significance. It may have the technical advancement as well as it may be less cheaper. So you can think your inventive steps must having technical advancement or economic significance, or both, then it can be patented under IPR. The third criteria was the industrial applicability. As per this section 21J, capable of industrial application means your invention is capable of being made or used in industry, particularly in a large scale. So in industry, the production takes place in a large scale. So whatever your invention, that should not be only to the lab scale, that have capability for production in a large scale, then that fulfill the criteria of industrial applicability and it can be protected under patent. So all these three criteria which is already defined in Indian Patent Act must be fulfilled by any invention, then it can be protected. These are the things which cannot be patented. Now anything you have designed that fulfill all these three criteria, but if they are related to the things which are shown here, that cannot be patented in a benefit of the country, like a defense and atomic energy related invention, it cannot be patented. Like if you have find out the method for preparation of any radioactive material, you cannot patent it because that will be not good from the safety of the country. So any such kind of methods, materials, this radioactive material, method for preparation of the radioactive materials, all these defense and atomic energy related invention cannot be patented. Living and non-living thing occurring in nature are non-patentable. Some chemical mixtures and the process of making that mixtures, that cannot be patented. Rearrangement of known device, one cannot rearrange the part of some device and it patent. If any device is already known, one cannot rearrange and get a patent for it. Scientific principles and theories are not patentable. Plants and animal in whole or parts like seeds, varieties and species are not patentable. Biological processes for propagation or production of the animals and plants are not patentable. And new form or use of known substance or machine is also not patentable. So some machine is already patented and somebody has developed the new use of that particular machine, then again it is not come under the inventive step and capability of the industrial production, so that cannot be patented. Here are some things which are non-patentable but they can be protected by the copyrights, and it includes mathematical methods, business method, computer softwares, cinematographic work, algorithms, literary work, aesthetic works, artistic work, musical work, dramatic work, TV production, all these are non-patentable but they can be protected by copyright, and copyright is one of the area of IPR. So definitely you will get the protection of your artistic creations, your dramatic work, musical work under this copyright section. Now here we will see the details about filing and patent application. Okay, so what are the methods, what are the forms, and what are the documents which are required, and what is the fee structure. One can file a patent application through different modes. The patent application can be filed to the patent office through online, it is known as an e-filing. It can be filed through post or it can be submitted by hand at a regional office. So these are the three ways by which one can file a patent application. Who can file the patent application? Now patent application can be filed either alone or jointly. It can be by true or first inventors. The true or first inventors are like researchers who are actually working on some problems. It can be a PhD student, it can be a research guides, or it can be done by the assigning of the true and first inventor. So sometimes the true inventors are assigned someone other person to file a patent, that become assignee. Or the third category, the patent can be filed by legal representative of the true inventor. So anything among these three can file a patent either alone or jointly. Now patent specification. For filing a patent you require the document that is known as a patent specification. It is known as form number 2. For filing a patent various forms are required. The form number 2 is very important. It is like your research paper. The complete specification or provisional specification. The complete specification include all the detail of your invention. It is particularly related to your technical details of the invention. Like you write a research paper. In research paper you are writing everything about your research, a method, its references, technical details. So all this come under this complete specification. And provisional specification. Now the two types of specification we will compare in the next slide. The complete specification is fully and particularly describe the invention in details. What it contains, it should contain the title of invention, field of invention, background of invention, advantages and uses of the invention, object of invention, statement of invention, claims and abstract. So your contain full details about your invention, including your claims. Claims are very important. They are giving you legal rights. So whatever you are writing in a claim, that is very this detail. But sometimes there is hurry and we don't have time to frame the claims, because claims are very important. They are giving you the legal rights. So we can skip the claim and we can file an provisional specification. In provisional specification, we are describing everything, all the essential feature of the invention, only we are skipping the claim. So whatever we are writing in a complete specification, everything we are writing in provisional specification, but we are not writing the claims, because sometimes we are in hurry, we don't have time to design the claims, because claims should be framed in very efficient manner. It should be framed very carefully, because claim is going to give you a legal rights. Whatever you are writing in your background of the invention, what you are writing in your field of invention, that is not important. Whatever you are writing in your claim, that is very important to get you the legal rights. So that's why the claim should be formed very carefully. So if we are in hurry, we can protect our invention through provisional specification, which include everything without claim. When we should go for the provisional specification, if research student is working, he has hurried to submit the thesis, in that case we can go for the option will be the provision specification. Any accidental disclosure, to protect it, we can go for the provisional specification. Or if there are many competitors in the same field who are working in the same area, in that case, to get your protection, you should go for the provisional specification. If you are having short of time, don't wait to frame your claim, write your specification and submit it as a provisional specification. What benefit you can get after submitting the provisional specification? First thing is that you get the priority for the invention, because you have filed the patent, it is registered in patent office. The first come first basis, that is the theory in patent office for the same invention. Who is come first, the priority will be given for that. So with the provisional specification, without wasting time in framing the claims, you can file a patent in a form of provisional specification. You will get the priority for the invention, and after you get registered, there is no risk of losing your priority, and you get more time. So you get liberty to develop your invention. You can disclose it to the interested person to obtain a financial support. Suppose you have some unique idea, you can give your presentation to some financer, you can give your presentation to some person which you can ask for the funding, and as your provision is protected, nobody can fool you or nobody can steal your ideas. Okay, so this is a benefit of getting provisional specification. You can utilize this time for exploring commercial feasibility, and all this is benefits you get. Finally, you are extending the term by filing the provisional specification. So invention to ask for the funding to the suitable important office. All these forms are not mandatory, and all these forms and documents are not required with each patent application. Okay, they are different documents and they are required in different cases. So if you want to file a patent application, you can just file it with the first 4 documents. The form number 1 is the application form. It just contains the detail of inventors and detail of the applicant. It is just a 2-page form. The second form is very, very important. That is form number 2, provisional or complete specification. It is just like your research paper. So this specification contains all technical details of your invention, like you are writing in a research paper. Same thing, you have to write a provisional or complete specification. Form number 3 is again an 1-page declaration for the foreign filing. It just indicate 2 sentences that I have not filed any foreign patent on the same. Okay, so it is just a 1-page form. Form number 5 is a declaration as to inventorship. So again, this is a 2-page form where there will be a declaration who is the applicant, who is the inventors, and all these things. So this 4 simple form will enable you to file a patent and give the protection under IPR. In this, form number 1, form number 3 and form number 5 are just 1 or 2-page forms, and form number 2 is a provisional specification or complete specification. It is just a document which you write like your research paper. So I am trying to say that a filing patent is very, very easy with this just 4 documents. Some other documents are not mandatory and it is optional. If required, they can be added with your patent application. Once you have prepared your documents, then you have to pay the fees for the patent application. The 2 things are important for the patent application fees. One is the fee shall be paid along with the documents, and second thing, it is a non-refundable fee. In any case, you will not get your fee refund. The fees are classified into 2 broad categories, just like a physical filing and e-filing. Okay, you file the physical patent, you have to pay the physical fee. If you file the e-patent, you have to pay the e-filing fee, and there is a 10% concession for e-filing. The patent publication fees structure can be further classified in 2 categories. One is for natural person and other is for person other than natural person. It can be either alone or jointly with a natural person. So natural persons are like a PhD student, individual researchers who are working in an academic institution. And person other than natural persons are the persons who are working in industry. They are doing the research in industry which are commercially established. Their annual expenditure is well counted. It can be a small entity and it can be the other than small entity. A small entity defined like a annual turnover having more than 250 crores will be entitled as a small entity, and the annual turnover of a company more than 250 crores, it will be considered as a other than small entity. So according to the origin, whether you are a natural person or you are the other than natural person. In other than natural person, where you are from the small entity or you are from other than small entity, the fee structure will be different. Here is the format of the fee structure for filing the patents. So the different charges of the fees are given here for natural person, for other than natural person, belonging to the small entity or other than small entity. So filing of patent application charges for an individual natural person is 1600. So this natural persons is like you and me who are working in an academic institution, who are doing the research and who are filing patents. They come under this category, natural persons. So the fee for filing the patent is 1600. Other fees are not mandatory, it is an optional. Like one want to get an early publication, they have to pay the additional charges 2500. Request for examination charges 4000. If your patent application means the form number 2 complete or provisional specification is more than 30 A4 size pages, then it will be no any additional charges. If your technical specification is more than 30 pages, then after 30 page sheets there will be charge of 160 per sheet. And in claims, if you are giving the complete specification and your claims are less than 10, there will be no any extra charges. But if your claims are more than 10, then after on 10 claims, there will be 320 rupees charge for each claim. So basically, there will be not more than 10 claims. Basically, there will be no more than 30 pages. So the patent application can be filed just within 600 rupees. If you count the 5% GST, it will be about 720 rupees. So one can file a patent only in one can file a patent only in 70, 100 or 70, 120 rupees. So it is a very low cost for filing a patent, but because of the unawareness that how much cost is for the patent application, lot of money is required to file the patent, lot of money is required for the patent procedure. Because of this unawareness, people are not interested to file the patent. So through this awareness webinar, I want to know that people should get aware about this IPR, and people should know that only 16 to 1700 rupees are sufficient to file your patent application and to get the patent. So definitely somebody interested should go ahead and prepare their file and file the patent application. Now this is very important slide of this workshop. Once you have filed the patents, the patent application will proceed through these prosecutions. Now, when you file the patent application at any regional office, you will go with the form number 1, form number 2, form number 3 and form number 5. With these 4 forms, you will go for filing the patent application. When you file the patent, your patent will get published after 18 months. As per the patent law, it will publish after 18 months. But if you want to publish your patent early, you can fill a form number 9 and you can go for the early publication. So early publication option is also given. After the publication of your patent, after 18 months, the people will come to know about your invention. For 18 months, your invention will be not disclosed. It will be safe to the patent office. After 18 months, when it gets published, it is available for the third party. So anyone can read your patent and they may oppose your patent. They may think that I have already done this, or this is my invention, I have already filed patent on this. So they can make a opposition on your patent. This is known as a pre-grant opposition. After this opposition, the request for examination will come in exist, and here you have to file the form number 18 for request for examination. Once you file the form number 18 for examination, your patent will be examined by the technical experts, and they will give the comments on your patent application. That is known as a FER, first examination report. You have to read all the comments, you have to give reply to each of the comments. That is known as a response to FER, and based on your response, the examination of the patent will take place and the decision on granting or refusal of the patent will take place. So at this stage, if your patent is granted, the patent will be published. Once the patent will be published, again the opportunity will be given for the post grant opposition. So again, the interested person can read your patent and he can oppose to your patent. The opportunity is given even after the granting of the patent. That is known as a post grant opposition. And once the post grant opposition is come in exist, the final decision will be taken by the controller of the patent office, and patent can be granted or it can be refused. So this is all the prosecution of the your patent application. Once it come to the regional office, it goes to the several steps: publication, request for examination, pre-grant opposition, post-grant opposition, and finally you get your patent granted. This is all about the patent prosecution. And also this is the end of this session. I conclude my session. These are some references which are used to prepare this presentation, which is available on this different website of the Indian Patent Office. I must acknowledge the organizer of this webinar, Honorable Principal Dr. Ganesh Thakur Sahib, Principal Mahatma Phule Arts Science Commerce College Panvel, Principal Dr. Meenakshi Gupta Madam, US College of Management and Technology, Uran, Coordinator Mr. Sopan Govai sir, and Organizing Secretary Mrs. Varsha Veer. I must thankful to Dr. Vishwanath R. Patil, Professor, Department of Chemistry and Director, National Center for Nanoscience and Technology, University of Mumbai, for giving important tips for making this presentation. Thank you.
Thank you,
Thank you,
sir.
sir.
Thank you
Thank you
so
so
much
much
for
for
this
this
enlightening
enlightening
lecture
lecture
on
on
IPR.
IPR.
Your
Your
knowledge
knowledge and clear presentation style has made this complex topic very easy and understandable. We are really grateful and thank you for sharing your expertise and insight with us. We have also been tracking the chat box, and till now there is no questions in the chat box. So I request all the participants to fill the feedback form which has been shared in the chat box. The link for the feedback of this today's workshop has been shared in the chat box. I request all the participants to fill this feedback form, and the certificates will be provided to you. We now move ahead with the presidential speech. Distinguished guests and my faculty members and student participants, it is with immense pleasure I invite Honorable Principal Dr. Ganesh Thakur sir to deliver the presidential speech. Sir has been a guiding force behind the academic excellence of our college. Under Sir's leadership, our institute has achieved a remarkable milestone. The college has been re-accredited with A plus in fourth cycle of NAC. The college has also received grant under DBT Star College scheme. Sir has also been nominated as a delegate on board of national and international collaboration by University of Mumbai. I invite Honorable Principal Dr. Ganesh Thakur sir to deliver the presidential speech and enlighten us with the valuable thoughts. Over to you, sir.
Thank you, Dr. Meshram, madam. At the outset, I pay my tribute to great social reformer and visionary educationist of Maharashtra, Mahatma Jyotiba Phule and Karmavir Bhaurao Patil, for their sacrifice and selfless service to the masses. Dignitaries present online for this one-day workshop: Dr. Meenakshi Gupta, Principal of Uran Education Societies, College of Management and Technology, Uran; Resource Person, Dr. Pramod Thakur, Department of Chemistry, Mahatma Phule, ASC College, Panvel; Professor Dr. Naresh Madvi, Dr. Rajaram Patil; Organizing Secretary Mrs. Varsha Veer; Head of Departments, Convener of this webinar, and Coordinator of Internal Quality Assurance Cell, Mr. Sopan Govai; all the participants from different states of India, faculty members, research scholars, and dear students. It is my pleasure to share my views on intellectual property rights as the president of this workshop. This workshop is jointly organized by our college and the UES College of Management and Technology, Uran. Friends, we have signed Memorandum of Understanding with Uran College recently to exchange the resources of both the colleges, basically to support the academic activities as well as the NAC accreditation process. As mentioned by Dr. Leena Meshram, our was accredited in fourth cycle of accreditation with CPA score of 3.29. Being the oldest college in this area, we are ready to support all other nearby colleges as per their need, as per their requirement. And hence, we have signed the MOU with the Uran College. And this workshop is a result of this MOU. We are also working as a leading college in the Parisparsh scheme of Government of Maharashtra. So University of Mumbai has given us a chance to support the various colleges of the Raigad district as far as NAC accreditation is concerned. We have organized this workshop basically on online mode, which is expected in National Education Policy 2020, which was announced by our Honorable Prime Minister. And it focuses on the 40% part of the academic programs that should be run online through online mode. And hence, this mode is preferred for this workshop. We are, we have become a techno-savvy persons during the COVID-19 pandemic, and we have used the technology very well in that period. And I think this is the best way to organize such type of activities. The topic which was selected for this workshop is a genuine topic and very important topic as far as every researcher is concerned. And this topic, intellectual property right, has a special importance in the NAC accreditation process because it improves your research performance in criteria 3. Dr. Pramod Thakur has given justice to this topic as he is a good researcher from my college. A college like us have 19 patents. My faculty members have published 19 patents. And out of that, Dr. Pramod Thakur has published 6 patents. And hence, he was selected as a resource person for this particular workshop. And I think he has given justice to the topic. If you have observed his presentation, he has covered all the things. What is the intellectual property rights? Which are the areas, which are the various subjects that can be covered under this IPR? Then how one can find the patents? What are the applications of these patents? Which things are to be patented and which things are not to be patented? Everything he has mentioned very well in his presentation. So I must thank him for his lucid and informative presentation. Now, my views on this particular intellectual property rights workshop is based on 2 aspects. The first is, why is it important to register intellectual properties? And the second aspect is, what are the benefits of the IPRs? While talking about the protecting IPRs, it is first necessary to understand the importance of registration. When an individual or an organization develops a new product, which involves a lot of process, content, and resources, a lot of time and money is invested. It is natural for the inventor or organization to have expectation of being able to own exclusive rights over the invention, while excluding others from benefiting from it. This exclusivity is provided through IP systems and IP laws. Although it is not mandatory to register an IP or trademark, it provides the inventor certain advantages, including the prima facie ownership proof that enables the owner to enforce IPR in the court of law if necessary. There are several dangers if IPRs are not protected. For instance, not protecting IP can result in getting benefits from the unprotected invention in an unauthorized manner to anyone. There is no law that can stop one from duplicating and seeking financial benefits from someone else's innovation if IP is not filed. Furthermore, it falls upon the owner to prove the ownership of the IP in a court of law if the IP is unregistered. If a trademark remains unprotected, the code cannot help the inventor, as it is not possible to claim ownership for infringement. Now, what are the benefits of IPR? There are several advantages. IPR enhances market value. Intellectual property rights can help you generate business through the licensing, sale, and even commercialization of the products and services protected under IPRs. This will ultimately improve the market share and helps in raising profits. Having registered and protected intellectual property rights can also raise the business value in case of sale, merger, or acquisition. The second benefit is IPR turn ideas and thoughts into profit-making assets. Ideas have little value on their own, but registering ideas under intellectual property rights can help you turn it into commercially successful products and services. Copywriting or licensing the patents can lead to a steady stream of royalties and additional income. The third benefit is IPR market your products and services. Getting intellectual property rights can help your business image. Intellectual property rights like trademark registration can help you separate your products and services from others. The fourth benefit is it access or raise the capital through sale, licensing, or by using IPRs as collateral for debt financing. An individual can monetize for debt financing. Intellectual property rights can be used as an advantage while applying for government funding like grants, subsidies, and loans. IPR enhances the export opportunities. A business that has registered IPRs will be able to use brands and designs to market its products and services to other markets as well. A business can also tap into the franchising agreements with the overseas companies or export patented products. Friends, I request you all, basically the students who are present for this workshop, the research scholars, and the faculty members, to utilize the knowledge and the information shared by our resource person today to protect your innovative research. Before I conclude, once again, I thank you all for making this workshop a grand success. Thank you. Thank you very much.
Thank you, sir. Thank you so much for your presence. Your words have provided us with a valuable perspective emphasizing the significance of this workshop and the importance of intellectual property rights in academics too. Thank you so much, sir. Dear participants, as we have now come to the conclusion of this insightful workshop, I request Mrs. Varsha Veer Madam to express our gratitude to everyone who has made this workshop possible and to felicitate and to express our heartfelt thanks who has been part of this enriching workshop. Over to you, madam.
Thank you, ma'am. Good morning, everyone. At the very onset of official vote of thanks, I, Mrs. Varsha Veer, would like to take these privileges to convey our heartfelt thank to Principal Dr. Ganesh Thakur sir for making this workshop a reality. Because without his support, this could not have been possible. On behalf of Principal of Rayat Shikshan Samsthas, Mahatma Phule Arts, Science and Commerce College, Panvel, and IC Principal of Uran Education Societies, College of Management and Technology, Uran, I thank today's resource person, Dr. Pramod Thakur, for facilitating us with a wonderful and insightful workshop on intellectual property rights. I thank all the participants, professors of all colleges for attending today's program. Hello. A special thanks to the organizing committee, teaching, technical, and non-teaching staff for their unflinching support and coordination. Our heartfelt thanks to our students for active participation. With these warm words and a kind message, we move to the end of today's workshop. Thank you again once and all.
Thank you, everyone. Thank you.
Thank you,
so
Vandana.
much, Ganesh sir. Because of you only, this workshop was possible.